International law firm Clyde Co recently held a seminar to update the market on international developments facing financial institutions and directors and officers. Speakers from London, Hong Kong, and New York were all present to update the audience, made up of in-house lawyers, insurance professionals, and company directors. We caught up with speakers and delegates and asked them why this seminar is important, what they hope the seminar will achieve, and what important issues are facing directors and officers today.
We are at the forefront of the financial institutions D&O financial issues for the market generally. Really, we're hosting the seminars in Hong Kong and in fact across Asia to bring the international issues, particularly from the London and US Bermuda markets, to the local environment to assist our clients. Everyone assesses risks, and that's exactly what we're trying to help them do.
So as underwriters, we always get questions from brokers every day in terms of not just policy coverage, but also how the legal environment is shaping, and also not just in Hong Kong, but around the world. So having a partner like Clyde's being able to bring in their partners from all over the world, namely UK and US and Hong Kong as well, these are the three areas certainly where we deal with the most, and seeing how the relevant laws apply and how coverage is going to be affected in the different territories. So for example, in the UK, the LIBOR issue has certainly raised the home, and the same practices that is in Hong Kong for the HIBOR, how they determine the interest rate is the same. So there could be some relevance in terms of the exposures to banks, and of course how the regulators look at how the HIBOR is determined can come in the future. In the US, we have seen our share of U.S. class action claims against Chinese companies. So it's always good to see how that law is developing and looking ahead in the Dodd-Frank and see how that's going to develop in the landscape as well. And same thing for Hong Kong. A lot of these changes, it will affect our clients. As insurance companies, we always have a very close relationship with multiple parties, not just including the insurance brokers, but of course our friends in the legal industry, where they're able to provide us with advice and giving us some development issues that we won't really see or keep an eye on. So it's always good to be able to talk to our friends in the legal industry, understand what's in the horizon so we can underwrite to the future, and at the same time to connect with some of our other colleagues in the industry and as well as the insurance brokers.
I hope the audience today will take away from the event and update knowledge on the status of the Hong Kong trend on directors and officers' liability, as well as the impact of the way Chinese does business on the exposure of the liability of directors and officers working in Hong Kong.
Issues we deal with internationally, particularly again in the US, Europe, in the London market, they're at the forefront of developments for the exposure for directors. LIBOR issues, market manipulation, mis-selling of financial products, liability of sponsors, Chinese companies being sued in the US markets, the introduction of class actions across Asia, a whole variety of issues which both in substantive civil and criminal law and in a regulatory sense adding to the exposures of directors every day.
The recent company's Ordinance Rewrite in Hong Kong is important because the objective of the rewrite is to lift Hong Kong to the international standards on corporate governance.
In terms of why directors should be aware of the changing legislation, it really comes down to Hong Kong. The company ordinance has been rewritten and putting into code the directors' duties and cares, and as they're acting towards their different stakeholders. That is absolutely relevant to all Hong Kong directors as they are looking to do their job properly and also have to answer to their stakeholders such as shareholders and even regulators and customers as well. Moreover, to the IPOs, that is one of the major fundraising activities in Hong Kong, and having that strict law against a sponsor, that will definitely, from an insurer's point of view, improve the risk, but at the same time, it will put directors at ease to know that they have a partner that is also acting in their interest as they're looking to raise funds in the public market, which is a very big step in any private company's lifespan.
That is all from this edition of Conventus Law Shorts. Please join us next time.